Mr. Simpson.
Before I start back, my Lord Kerr asked me about the automatic right of appeal in these cases. Could I just direct the Court's attention to Section 5, subsection 7 of the Act? Just see that a person, subsection 7 of Section 5, a person convicted of an offence on a trial under this section may, notwithstanding anything in the Criminal Procedure Law and Ireland Act, appeal to the Court of Appeal against his conviction on any grounds without leave.
Yes, thank you.
I have been dealing with my Lord Kerr's remarks in Sugar and the issue of pragmatism when it comes to the reviewable nature of the review of the records. It's the attorney's decision. Could I make some general points? First of all, that if this court determines that any review should be other than at the bottom end of the scale of review, then of course the requirement for procedural fairness would apply to condition 1, condition 2, condition 3 and condition 4 cases. It couldn't just be confined to condition 4 cases, so we must go through side the fact that will involve the same procedural requirements in all of the terrorism cases. And the learned friend identifies 3 things: representations, and if we ask the rhetorical question, first of all, from whom will these representations be obtained? We just have had an announcement, I'm sure the court may be aware of it, that a soldier is to be prosecuted in the bloody Sunday shootings in relation to a couple of murders, I think 4 attempted murders. If the representations are to be taken by the director, they presumably will include representations from the defendant, but should they also include representations from all the families who have a legitimate interest in whether it's a trial by jury or a trial by judge and oath? Should it also include representations from pressure groups such as the Bloody Sunday Families pressure group? Does it involve potential input from politicians? Will it involve counter-representation? Will you be allowed to see the representations made by one side? This is all to do with the issue of pragmatism. Where is it going to stop if representations are allowed? Will there be judicial review by the families if they're not allowed to make representations to the director? One is conscious of the need to avoid satellite litigation in these types of cases. And if the door is open to representations from a number of people, even if it's only the defendant and the family of the victim, then that opens the door to potential challenge for 2 sides of litigation. As far as reasons are concerned or disclosure are concerned, a number of these cases are terrorist cases. And some of the information that will be received by the director will be sensitive information from intelligence sources. Our friend says, well, it can be gisted, but sometimes even gisting of information can give rise to potential jigsaw identification of, for example, covert intelligence source. And so is one going to have a challenge then from the defendant in a case like this to the amount of gisting, to the amount of information made available to the defendant? So we respectfully say that there are difficulties which will be created if the principle of exceptionality is attenuated in any way in these cases, so that one is left with the real possibility of satellite litigation. And I've asked for some statistics, and in the last 11 years, from 2007 to date, there have been something like 225 certificates issued. There have been
225.
225, of which this is one, and 2 soldiers, A and C, whose judicial review is waiting in the wings until after this court's decision, is another. In that period of time, there have been 3 judicial reviews. One is Arthur's case before the Lordships of the Leadership. One is this case, and one is the parked A and C, which is before the Divisional Court in Belfast at the moment. And it is, in our respective submission, reasonably to be inferred that the absence of satellite litigation, the minimal nature of the judicial reviews, is because of the decision in Sugar and then the decision in Arthur's, indicating that the full panoply of judicial review is not suitable for this type of decision. And we respectfully urge upon the court not to open the door to satellite litigation, not just in soldiers' cases, but in terrorism cases as well.
Well, if the director took his decision in a case where he didn't have to evaluate sensitive information, is there a case to be made that in those circumstances the procedural fairness requirement would be activated?
Well, we'll have to define very carefully then, Lord, what procedural fairness meant in each case. And it would be difficult to circumscribe it in such a way that it could only be in cases of sensitive information. No, it doesn't have to. But even in those cases, one knows that there may be sensitive information coming from a number of sources. Some of it may be possible to just, others might not, other parts of it may not be possible to just. How is one to draw the line? How is one to deal with the judicial review challenge of a defendant, a terrorist defendant, who says, I want to know what information you had, I want the gist of the information you had. The difficulty, my Lord, in our respectful submission is that once you open that door, it's impossible again to close it. There will be satellite litigation, there will be judicial reviews. It's the decisions of Sugar and Arthur's that have kept those at bay, as it were. And in our respectful submission, that is a matter which should be taken into consideration by this court before deciding, before looking at the issue of representation, disclosure and reasons. And it's right to say that in both Sugar and Arthur's, the court took the view that the level of scrutiny should be at the very least intrusive end. If I could take your Lordships and your Ladyship to Arthur's, which is in Volume 1, third of Volume 1, under Tab 1. And passage that the court has already seen, page 280 of the volume. Just below the quotation from Kibbley, the court says, it's apparent that the statutory language in Section 7 is inspired by the principle of exceptionality, applicable in the context of prosecutorial decisions. Section 7 gives statutory recognition of the common law reticence in the scrutiny of decisions made in the field of prosecutorial decision-making. The wording lends support to the contention put forward by Mr. Maguire and Mr. Perry that a decision made by the Director under Section 1 is intended to fall within the band of prosecutorial decision-making. The precise parameters of the limitations arising from the concept of exceptionality are not defined. This is equally the case in judicial pronouncement in the case law. Lord Justice Law's coined the phrase a sliding scale of review to make clear that the degree of intensity of judicial scrutiny depends on the context of the issues before the court. It will be influenced in part by the legal scheme under review. And the legal scheme in this case was giving the Director the personal decision based on very low thresholds to the decision to issue a certificate. The importance of the countervailing rights of interest and the extended interference with rights of interests. In cases engaging the most highly protected of the Convention rights, the degree of scrutiny will be the most rigorous kind. Case law speaks in terms of heightened or anxious scrutiny, or of a close and penetrating examination of actual justification for the acute interference with the right. In other situations, the court will adopt what is being called a light touch review. Within that sliding scale of review, the review of a decision by the Director under Section 1 is, by the statutory effect of the wording of Section 7, clearly demonstrated to be one falling within the least intrusive side of the spectrum. That's the point that I have been looking to the Lordships every day. If the court then turns to paragraph 33, page 284. And again, paragraph 33, for once it is concluded that no breach of Article 6 has occurred, the applicants rely on the argument that the decision-making process infringed the principles of common law fairness. Those principles, it is argued, demanded that the applicants should at least should have an opportunity to have at least the gist of the case against them so as to enable the applicants to make representations before a decision is reached. The director's alleged disregard of the dictates of common law fairness, it was argued, constituted an error of law initiating his decision. Counsel argued that Section 7 of the Act and its limitations on the judicial review of the director's decisions could not be construed so as to exclude a judicial review of the director's decision for procedural unfair. The argument that the director's decision must be quashed for procedural unfairness must be rejected. As Ray Shuker shows, it is not every decision-making process which demands procedural fairness in the sense of requiring the decision-maker to consult the party affected or to make them aware of the nature of the evidence being relied on if an initiating decision adverse to him. The nature of the statutory conditions, suspicion and a risk to the interests of justice, involves matters of impression and evaluation and judgment on the part of the director. A suspicion once formed on the basis of sensitive intelligence material usually of such a nature that it could not in the public interest be disclosed to the defendant unless it could be wholly dispelled. The MC Dixit of the defendant denying any ground for suspicion is not going to dispel a suspicion properly formed on the basis of intelligence advice emanating from a apparently reliable source. The nature of the exercise to be carried out by the director does not, as pointed out in Ray Shuker, lend itself either to the full panoply of judicial review or the implication of the duty to seek or receive representations before the director forms a suspicion. Our respectful submission, that is the level of scrutiny which should be applied to this decision, because otherwise one has the spectre of satellite litigation, and that is to be avoided in our respectful submission.
Well, I can quite see the argument that the director has to take. I can quite see the argument that the director has to take what's an evaluative judgment, or make an evaluative judgment. But does it not also partake of consideration of information?
Yes, it depends on information. There is some information that the director has explained that he received information from the police.
Well, not necessarily in relation to this case, but could it not be said that where information forms part of the background to the decision, if it's to be anticipated that the person affected by the decision might shed a different light on that information, that he or she should be given the opportunity to do so?
Well, first of all, Lord, that would only apply if the information could be shared, or enough of the gist of the information so that the person could make informed representation. But it may be, as your Lordship knows, it may be that there are many cases where information, even gist of it, cannot be given because of the very real risk of infringing the article or even the fact that information exists. Sometimes intelligence exists, sometimes it can be a problem for the prosecuting authorities. So, in order to try to produce rules or a framework in which representations can be made, disclosure can be made, and reasons can be given, one has to move away from this case and look at all of the cases which come under conditions 1, 2, 3, and 4. As I say, my lords, only 2 of the 225 cases are soldiers' cases. The rest are cases involving terrorism. So one is in danger of producing a framework in the background of this case which will be wholly unworkable when it comes to dealing with terrorism cases. And in our respectful submission, one needs to be very careful about that. So far as the reasons are concerned, my lords, it's our respectful submission that when one reads the pre-action protocol letter reply and the affidavit, the reasons are clearly set out, both in relation to Section 1.2a and Section 1.2b.
Well, has the director ever said that his decision was informed by information which he cannot?
No, that's not this case, my lord. No, that is not. This is not an intelligence case. Or the director has said that he was informed by information from the police and an opinion from senior counsel. I think your lordships will find that on 157 of the papers. And just take the court to that just to see if that's right. Yes, in the initial decision letter, which is in core bundle at page 157, Lordships and your ladyship will see the second paragraph of the letter of the 10th of May. I can advise you that the Director suspected that Condition 4 in Section 1 of the Act was satisfied on the basis of information provided by the police, coupled with a commentary and assessment of that information, an analysis of the facts and circumstances of the case, and the advice of senior counsel. So those are the three sources of information in this case.
Well, on one reading of that, he did have information, but he doesn't go on to avow that information fell within a sensitive
No, Lord, and there's never been, the case is not being made, I'm not making the case, and the Director has never been making the case that there is sensitive intelligence information in this case. The point I'm making, my lords and my lady, is that if this case forms the basis of the framework for what should be done in all of the cases under Section 1, one is in danger of producing a framework from what is in fact quite a simple case on the facts and doesn't have intelligence information and doesn't have chises in the background, etc., etc. But if one creates a framework arising out of this case, it has to be applied in every case, and that's the danger. The danger is that we will have satellite litigation because a defendant will say, well, in a soldier's case, you're going to give him information, but in my case, you're not giving information, and then one has the danger, let's say, of judicial review. That's why we respectfully say that the judicial review, the actual review, is at the lower end of the spectrum, precisely because it is a personal decision of the Director in the circumstances with low thresholds. And one imagines, my lords, but certainly the legislature would have been informed by the fact that there is there are no challenges worth. There's only been Arthur's since the Act was passed, and Sugar before the Act was given in force. At that stage, there were two judicial reviews in respect of that type of decision. So the reason for that, of course, is quite clear in our respective submissions, because the anticipation of the parties is that the level of scrutiny will be at the least intrusive end, and we respectfully urge upon the court to maintain that. I
suppose it could be said in this case that in the reasons given by the DPP, he in effect has set out the gist of the information that he was given in his 15 points of paragraph 12.
Yes, my lord. Yes, my lord. I respectfully agree with that.
So that if the appellant wanted to say, well, I wasn't there, or I wasn't in the patrol that day, he would have had the opportunity to say that.
Yes. Or there was no shooting 2 days before. That's just wrong. He could have said that, yes. But there is the context of the shooting, that is, the circumstances giving rise to the commission of the offence are set out in that letter. And then the Director goes on to discuss the issue of perverse verdicts and referred specifically to Mr. Justice Stevens, the Court of Appeal, and the McParland case, which was my Lord Kerr's case, setting out the danger of perverse verdicts. So insofar as one's looking for reasons, the reasons are clearly there in our respective submission. And that's why in our respective submission, the Divisional Court in this case described that as being self-evident. And so we respectfully say that reasons have been given. The disclosure of the documentation has not been given. I accept that. And representations were not called for, but we respectfully say that it would be dangerous to envisage a framework whereby representations would be made for all the reasons that I've already explained. And we respectfully say that's why the level of scrutiny is at the least intrusive end and should remain so in our respective submissions.
If the appellant wished to make representations now, would they have to be considered by the Director?
If representations were received tomorrow, for example, the Director, in my view, couldn't ignore them. The difficulty I'm trying to bring to the court's attention is once you have a situation where representations can be made, what is to stop the family of the victim or victims making representations? And is the Director susceptible to judicial review? He says, sorry, I'm only going to take representations from the defendant. And then where does the process start? Is the family entitled to see what the defendant said? is the defendant entitled to see what the family has said in order to counteract anything that may work on the mind of the director. So we respectfully urge upon the court, therefore, to be careful about what it may say about the procedural fairness aspect of this particular section of this legislation and for the background to the legislation and the wording of the section.
Can I ask, is it the practice of the DPP always to give reasons when he issues a certificate? How does it work?
It's not been, may I just take instructions on that point for a moment? No, it's not the practice of the director to give reasons.
So usually you just get a certificate?
Usually just get a certificate, yes. And at the moment, the law in Northern Ireland has been Shooker and Arthur's. Yes, thank you, Lord. So that's the basis on which the director deals with it. Is any other matter? Those would be our submissions.
No, thank you very much, Mr. Simpson. Mr. Shields, do you have anything to add? Thank you very much. Mr. Lewis.
Well, I'll make some short points. First, my learned friend turned to the case of Jordan. For your reference, it was Volume 1, Tab 6, page 402, paragraph 82. I don't ask you to turn it up, but it must be treated with some care because Jordan was an inquest case. And of course, inquests require a unanimous verdict. And that was part of the strong reasoning behind the court, that where there were unanimity requirements, bias would play a different approach. Of course, here we have different factors such as majority verdicts and no preemptory challenge. The passage my learned friend took us to in the short extract he handed up at page 272 emphasised the requirement that the exact nature of the perverse verdict is influenced by the geographical location of the inquest. Of course, that's not a factor here, as the trial will be in Belfast. Secondly, my learned friend turned to pointed out the fact that, or made the submission, that suspicion is not a decision. We fundamentally agree with that. Just as a decision to arrest can be based on suspicion, it doesn't stop it being reviewable. The fact that it's a suspicion is nothing to the point. The director is exercising a statutory provision. And what has happened here, when my learned friend pointed out this wasn't adjudicatory, we emphasise the position that if a decision to prosecute is to put proceedings in motion, that's obviously not adjudicatory. However, once you're in the criminal proceedings themselves and a party makes a decision on the procedure involving a fundamental right, that is adjudicatory. And in fact, it seems that he does so on application. I think Fred made some plea that it would be terrible if there had to be a standard of procedural fairness in this matter because there would be representations from families, press groups, etc. Well, my lords, we do say, one has to be very careful on that. Fairness should not be sacrificed to the altar of pragmatism. Difficulties that occur in all public law decisions. Judicial review in itself requires the filter of permission. And as a general principle, interested parties are not part of the process of a criminal prosecution. So it really doesn't lead anywhere to make that point. In effect, his submission is, it's okay to take away a fundamental right of the appellant in secret without representations because it's too much trouble to impose fairness on taking away that procedure. We say that that argument should be rejected. The next point my learned friend made was in relation to Ree Arthur's case, paragraph 26, where he seemed to support the fact that convention rights would be subject as the court there said, to anxious scrutiny. It's difficult in our respectful submission to distinguish between convention rights being subject to anxious scrutiny and a fundamental right, such as right to trial by jury, not being subject to the same level of anxious scrutiny. It needs the same protection. At the next point, Maloney...
Just since you raised the question of convention rights and fundamental rights, it might be said that Article 6 of the Convention, which requires trial of a criminal charge within a reasonable period, is a reason why a state may wish to limit what has been described as satellite litigation, which will inevitably delay a trial coming on and may ultimately make fair trial impossible. What would you say about that?
Well, that can happen in all cases.
Yes, but
there are many cases. It's not satellite litigation.
Right.
It's not satellite litigation because it's simply in the criminal process. The mere fact that you could judicially review a committal for trial, which in itself may hold matters up, is nothing to the point. And indeed, the entire trial process has to be seen as one. And therefore, if there is an element such as unfairness in part of it, it can't be right to simply say, well, just in the interest of getting on with it, we'll ignore a fairness procedure on that, or one particular party is able to make a decision in the process without reference to the court.
It's sometimes said that where you have fundamental rights which are pointing in different directions, that tends to make the margin of appreciation or area of discretion for the state in legislating.
Well, there is no
much
fundamental
wider.
right pointing in the other direction here. There is only the right to trial. It's going to take just as long, or wouldn't necessarily make any difference if it was trial by judge alone. In fact, given that you have an automatic right to appeal, the process might be longer in total. We certainly don't accept that there is the satellite litigation is a good point.
Can I ask you, you were saying what difference it makes. I'm wondering at the moment what difference a right to make representations, what difference representations might make. In the present case, for example, has anything been said that would put in question the director's decision?
Well, we don't accept the bias point or the correlation that comes from the fact that there is we would make strong representations that any suspicion that there would be an interference with the administration of justice can be countered. The presumption these days, particularly with the normalisation of the process in Northern Ireland, is that jury trials should be the norm.
So you would make a representation that apprehensions that there might, in a jury trial, be a member of a jury who was biased are unfounded?
Or can be sufficiently dealt with
And how
by
would you,
the other matters which the director does not appear to have considered.
And what do you have in mind?
Well, he does not appear to have considered the import of preemptory challenges being abolished by Section 13. He does not appear to have taken into account.
What difference does that? I mean, I can see that the possibility of peremptory challenges makes a difference to the composition of a jury, but the absence of it, I'd have thought. Well, tell me, how do you think that makes a difference?
The whole purpose and all the working papers, etc., put forward as a very strong factor in preventing biased juries or perverse verdicts, the fact that the preemptory challenge has been abolished, because it prevents counsel or representatives stacking the jury with people they think would give a more favourable. So what's happened, certainly in the United Kingdom, is that you just take the first 12, come what may.
Oh, quite.
And that we trust the jury system. And in those circumstances, we have trust in the jurors to deliver a fair and honest verdict according to the directions that are given by the trial judge.
Yeah.
And that's all part of the normalisation process there. And insufficient weight has been given or we would be arguing insufficient weight, has been given by the director to those matters.
Do you not think the director is well aware that in the absence of peremptory challenges, the jury will be, in principle, a random selection of members of the public?
Well, you say that, my lord, but he doesn't say so in his reasons, and he doesn't say so in his affidavit. So in this particular case, there's no evidence to base that upon. So when you're putting to me what representations I might make, it must be valid to make things which he hasn't said he's taken into account and which it doesn't appear he's taken into account. He certainly hasn't taken into account the Attorney General's guidelines on enhanced jury vetting. One just doesn't know. So what we would respectfully say, Your Lordship shouldn't fall into the trap of inventing reasons for the director in a public law challenge. And one has to look at it from the position that, particularly in this case where my lay friend says this is not an intelligence case. So why weren't we given the information?
Sorry, what information?
The information or material upon which the director made his decision. My Lord Sells has put out the paragraph 12.
Yes.
Those are some matters. But those couldn't possibly go to jury bias, for example.
I don't think it's suggested that they do, but they go to the suspicion point on the subparagraph A.
They may do, my Lord, depending on the approach he's taken to the construction of the section. So, and of course, in this case, the certificate was we were given no notice for a year. It was only when we came to be arraigned on the very day of arraignment in court that we were told the certificate had been issued. So the certificate was issued in April 2016. When we came to be arraigned on the day of arraignment in Belfast Crown Court, the certificate was shown to us. We hadn't known for a year that a certificate had in fact been issued.
Sorry, and can you tell us the date?
Yes, I
of
can.
that?
If we look at the statement of facts and issues. It was I don't think it's actually set out in the chronology there. It's 5th of May, paragraph 17. Because,
Right, that's the date,
yes,
date of arraignment, is it?
there was an original issue taken by my learned friend but abandoned upon affidavit that we were out of time to judicially review because our judicial review didn't start till some 14 months after the certificate was made. And the point being, we had no notice of the certificate until we came along to the Crown Court for arraignment.
And was it on that occasion then that it was said, well, we will wish to challenge that certificate, so can the arraignment be postponed?
Yes.
To preserve
Exactly.
your ability to challenge?
Exactly.
Right.
It's exactly. So this isn't a case where, we knew about the certificate and did nothing for a year. We came along immediately on the day of arraignment and dealt with that. We do say that what is in effect an inter rorem argument made by my learned friend should be rejected, that it would open the floodgates, that if it introduced a standard of procedural fairness which would be troublesome to the director. And I'm not sure if my learned friend was intimating when he said it's the first information we've been given of it, that there were only 2 soldiers' cases. I'm not sure if my learned friend was intimating that they automatically come within condition 4. But of course,
I don't think he was suggesting that.
But the information in the affidavit, which was paragraph 15 and the paragraph 12, the 15 points, and the reply to the pre-action protocol letter, is information which was given after the decision was made. And what we do say, the fact that you can ask for a decision maker to reconsider his decision after he's made the decision is not a reason to say that you can't challenge or say that the original decision was fair. And I simply close with this, my lords. This is a fundamental right. It shouldn't be treated in a cursory manner by the director. And to take away someone's fundamental right while the proceeding begins demonstrates that it might be described as an inequality of arms, because we're within a trial process and one party to the process can unilaterally change the procedure without reference to the court or without allowing representations to be made. Well, my lords, my arguments I don't think are going to improve with repetition. So unless I can assist my lady and my lords any further, those would be my submissions.
Thank you very much indeed, Mr. Lewis. Well, we're most grateful to all counsel for their assistance, and also to those sitting behind them who've contributed to the preparation of the arguments that we've heard. This is obviously an important question. We'll take time to consider it, and you'll learn our decision in due course.
I'm much obliged.